the meeting to order. This is the August 13, 2019 meeting of the Town Plan and Zoning Commission for the Town of Fairfield. Some housekeeping. Those who are here that weren't here last time have all come up to speed. Commissioner Noonan, Commissioner McAleese.
Yes, sir.
All right, and Commissioner Elliott. Great. So Commissioner Elliott, you're going to be sitting in for Commissioner Meyer for the entire evening. Okay. Great. So the first item on our agenda is the meeting minutes from July 23rd, 2019. Do we have a copy of that? Do I have a motion? Someone?
Move to approve.
Sorry. Motion to approve by Commissioner Levy and seconded by Commissioner Noonan. Okay, thank you. I reviewed them, didn't find anything to comment or correct. Anyone else? Okay, all in favor say aye.
Aye.
Any opposed? Abstentions? The minutes are approved unanimously. Next is new applications to recommend public hearing. We have one. It's a zoning regulation amendment, application of the Hull House Group LLC to amend 12.5.5 of the zoning regulations, residential use in the neighborhood design district.
Mr. Chairman, this proposal is to modify the provision of the neighborhood design district, maintaining 50% residential maximum in the neighborhood design district, but allowing proposing to allow ground floor residential occupancy in buildings where there's more than one building on the property in one of the buildings. So it is a proposed reg amendment that does require public hearing.
Yep. Okay. Yes, question?
No.
Mo-
Make a motion to move to a public hearing as
Great.
required.
Yep. So moved by Commissioner McAleese, seconded by Commissioner Noonan. McAleese and Noonan. Very good. Any questions for staff? Cool. Hearings required. Okay. All in favor, say aye.
Aye.
Any opposed? Abstentions? Okay. Move to public hearing unanimously. Next is old business, 491 Turney Road, 880 South Benson. Oh no, this one was removed, right?
No, Fairfield Beach Road public hearing.
Forgive me. Yeah, sorry. This is a coastal site plan and special permit application in the town of Fairfield for marina dredging and beach renourishment in the A zone. Right.
Okay, Mr. Chairman, this is a coastal site plan and special permit application for the dredging of the Marina Navigational Channel. This plan has the approval of the Army Corps of Engineers, as well as a permit from the Connecticut DEEP. As a condition of the state permit, the town must utilize the dredge materials to renourish Jennings Beach, which is adjacent to the channel. The proposal supports the coastal use policies of enhancing recreational opportunities along the shorefront by enhancing the navigational capability of the marina channel. The beach nourishment will also provide an additional reservoir of sand, not only for Jennings Beach, but for other nearby beaches as tides allow the sand to migrate over time. Overall, this plan is consistent with coastal resource policies, and again, the plan to the disposition of the dredge materials on Jennings Beach was a condition of the state DOP permit. That is all I have, Mr. Chairman.
Okay, thank you. Can I have a motion?
Move to approve.
Motion to approve by Commissioner Noonan, second by Commissioner McAleese. Any comments?
Only that it seems everybody who's looked at this either approves it, requires it, or recommends it with no opposition. See no reason to deny.
All right, okay. So the material that is to be dredged and repurposed, that's not going to leave the area. That is going to stay either within the marina and the Jennings Beach area.
Correct.
And
There is one small area of material that's not, it's a small amount that's not suitable for the beach, that's going to be dewatered, kept in the marina, and then ultimately transported off site, but it's a very small amount of material compared to the balance of the material. It's going to be hydraulically pumped from where it's being dredged straight over to the beach.
Okay. That material that's being taken off-site, that's not taken to the Richard White Way?
Not to my knowledge, no.
Okay. All right. Very good. Any other questions? Okay, all in favor, say aye.
Aye.
Any opposed? Abstentions? The application is approved unanimously. Next is 1073 North Benson Road, special exception application of Fairfield University pertaining to the construction of a new convocation athletic facility to replace Alumni Hall.
Okay, Fairfield U, as you just mentioned, Mr. Chairman, is seeking to replace their existing Alumni Hall facility with a new arena and convocation center. For a basketball game day, the existing Alumni Hall seating capacity is approximately 2,500 people. The new facility would be 3,500. The parking required for a 3,500-seat arena on its own is 700 spaces. Notwithstanding that it's anticipated that a fair number of the attendees are likely going to be students that are already on campus, the university has provided a map showing that there are 962 parking spaces on campus in close proximity to this building, as well as a total campus inventory of 3,400 spaces. With respect to traffic, the traffic report indicates that the increase in seating will result in a game time traffic increase at various entry drives from 2.3 to 5.3% above the existing game capacity conditions. And the biggest impact that was shown in delay is in the exiting left-hand turn movement at the main access drive on North Benson Road. So that would be traffic leaving the campus looking to make a left northbound onto North Benson. It was noted, however, that this additional queuing will take place internally with the university property and not on North Benson Road. And this is a condition that presently exists when other similarly attended events occur, and they pointed mainly to Fairfield Prep football games as where that it's already taking place. It's a limited amount of time in a queue that is internal to the university's property. The relevant standard considerations for a special exception are as follows: is the location, type, character, and size and use of the buildings in harmony with and conform to the appropriate and orderly development of the town and neighborhood, and not hinder or discourage the use of adjacent property? Is the nature of the location of the use in buildings or structures such that there will be adequate access for fire protection? Are the streets serving the proposed use adequate to carry prospective traffic with provision made for entering or leaving the site without creating undue hazard or traffic congestion? And is the proposed use in compliance with the plan of conservation and development? That is all I have for now, Mr. Chairman.
Okay, thank you very much.
Move to approve?
Motion to approve by Commissioner Noonan,
Second.
second by Commissioner McAleese.
Corcoran.
Corcoran. God, I do it all the time.
Let's switch places.
I know it. I'm so sorry.
You're throwing your
I
voice.
know your names. All right, Commissioner Noonan, do you want to start your motion?
Just that this is an application that seems to be supported or wanted by the entire Fairfield community. I think a lot of people are excited to have seen it. I'm sure when I first saw it, I was excited to hear the application, make sure that we could hear it and it would go through. It seems to meet all four of the requirements for a special exception. It's on campus, so certainly in harmony with the neighborhood as it being interior. I saw no issue when I was listening to the video about fire protection. I expect Fairfield U would certainly be cognizant of that. During the presentation, it seemed like there was a good discussion on traffic. Mr. Chair, you're leading the charge. If you have any other comments, I'd certainly like to hear them. But considering the issues, the main issue would be an internal queue as people were leaving, and the lack of any opposition seemed like if there was any issues in the neighborhood, they were willing to accept them. It didn't seem like there'd be any trouble with the street, and overall would be a good application that we would want to approve.
Okay, very good. Yeah, I mean, I have a couple comments, but I'll wait until others have spoken. Commissioner Corcoran?
I do not have any additional comments. I agree with what Commissioner Noonan said.
All right. Anyone else? Commissioner Levy? Okay. Yeah, so I mean, look, that was my biggest area of inquiry. You know, it's a beautiful building, doing great things at Fairfield U. You know, we're seeing a lot of development on, you know, both our university campuses, expansions, both in terms of facilities as well as beds. traffic is a concern. We didn't hear any notable opposition, right? Members of the public, as you, I think, correctly note, is favorable. But I found that the traffic report to be, you know, a little fuzzy with some of the delays that were, you know, noted, particularly where they compared the no-build, the build to, like, I expected it to take into account the construction of the facility, which we talked about at the hearing. But I think at the end of the day, you're right in that the traffic is going to be internal on the campus, and you know that it's somewhat larger than the facility is today, but it's not that much bigger. That I think it should be fine. So that's, after having thought about it, that's my comment. Anybody else? Okay. Sure, Commissioner Elliott.
I was wondering about the traffic at Loyola. If there's like a police presence there, maybe that would make that a little smoother just during game days. I don't know if that's something that we can have any say in, but it's a suggestion.
I don't know if that's something that we can mandate. I think the university has a long history of cooperation with the Fairfield Police Department and can utilize that if they need to. The other thing I would say is, should the commission approve this, it still need that North Benson Road's a state highway. It still needs to get approval from the state. What the entity that used to be known as the State Traffic Commission, that's now called OSTA, the Office of the State Traffic Authority, I want to say, but I'm not. Don't hold me to that. I'm still referring to it as the State Traffic Commission. But they'll still need to get a certificate from them after reviewing the traffic information as well. So I mean, we can make a recommendation that they reach out to the PD for assistance in directing traffic on event days, but I'm confident that they would do that of their own accord if they
Well, I mean, so the way to do that would be to suggest a friendly amendment to the motion to approve and include a recommendation that the university coordinate with Fairfield Police Department and, you know, have someone to direct traffic if you were inclined to do that.
Inclined to do so.
Yeah.
Sure, I'm inclined.
Okay.
While I can speak.
Very good. So, Commissioner Noonan?
Yeah, I'm always favorable to friendly amendments. I suspect that Fairfield U would do that on its own accord, but I don't believe it.
We hope so.
I believe a little recommendation would not be
All right.
a problem.
And they might already do it with
Yeah.
football games. I'm not sure if that's but if it's
Right.
a little bit more
Okay.
people.
Commissioner Corcoran?
Fine with me?
Okay, very good. So the motion's been amended to include the recommendation. Any other comments?
Mr. Chairman.
Commissioner Francis? Yeah. Yes, it is.
I think that's a very good idea.
Excellent. All right, anything further? All in favor, say aye. Aye. Any opposed? Abstentions? The application is approved unanimously with the recommendation. Next is 1073 North Benson Road, special exception application of Fairfield U pertaining to the construction. No, I just did that.
You did that.
Apologize. Next is compliances. 515 Commerce Drive, compliance application of Paula Murphy for a pole sign in the Design Industrial District.
This location, the location of this proposal is within the Commerce Drive Area Design District with a Design Industrial District underlying zone. The 60 square foot pole sign is proposed where the regulations would allow up to 100 feet. The underlying zone requires a street setback of 25 feet, while the Commerce Drive Design District regulations require a minimum setback of 5 feet and a maximum setback of 18 feet. The proposal here is for a 7-foot setback from the sidewalk, which denotes the property line here. Section 29.13 of the regulations does require that pole signs have 2 supporting uprights. Therefore, if approved, a second leg, if you will, needs to be added to this sign, but it otherwise is, complies.
Okay. So that would be a slightly different design with 2 legs.
Right.
Okay. All right, very good. So we can get talking. Do we have a motion?
Move to approve with conditions from staff?
Okay. I think it would be, well, I'm not sure, that conditioned upon a new drawing that would be compliant with our
Yeah,
regulations for review by staff.
I would imagine that rather than the center pole, they just have a pole on each end.
Yeah. I mean, I suppose then that also begs the question as to whether or not they would, they have to alter the number, which having the number is a requirement of the regulations, and where that would be and how that would look.
Yeah, they could put a panel underneath with the number on it instead of having it on the pole, but we can make it subject to.
Yeah, in which case it's a different drawing, but, all right, so the motion is to approve with a condition for a new drawing to be reviewed by staff and compliant with our regulations. Commissioner Noonan?
Yes.
Yes. Second?
I'll second.
Okay, Commissioner Corcoran seconds that. I think we should talk about how that might work. You know, we typically want to see these things, polls, or sign applications, see what they look like, how the number's going to be represented and so forth. And so, I don't know, how do you think that would work? Commissioner Noonan?
Sorry, what's the question?
Well, I'd forgotten that there were numbers on I just thought if there weren't numbers, you just add the poll on either side and it can be administratively reviewed by staff, but probably can be done that way anyways as well. I'm open to suggestions. Just hearing that the sign had complied except for the 2 stands, so to speak. My thought was that something could be done administratively without coming back to us, but maybe it would be cleaner just to deny and have them come back, deny without prejudice and have them come back to us.
I mean, Commissioner Francis?
One question, the picture looks like the sign is taller than the building, is it? Or
No.
is it just the angle?
The maximum sign height is 15 feet to the top of the sign.
And the building is 25-ish?
Yeah, it's taller than,
Yeah.
It's not taller than the
Yeah, it's a one-story
building height.
building.
Yes.
Taller, okay.
I have a question.
Yeah, Commissioner Corcoran.
The sign is photoshopped into the photo. Are
Yes.
the flowers also photoshopped in?
No, those exist.
Okay.
That's a good question. I wouldn't have been able to answer that myself.
I have one more question.
Yeah, Commissioner Francis.
Are the panels removable as one company goes out of business and it's replaced by a different tile company or something?
I don't know whether it's one sign face that can be the signs, whether there are 3 different sign face panels or whether it's a singular panel, but in either case, it can be removed and replaced.
Yeah, it
No,
says there's a
not an
divider
awful lot of
bar, so
harmony in the building.
I think it-
Literally.
Well, you mean with respect to the lettering?
It's probably on purpose.
Yeah.
Yeah.
Each little company logo. Doesn't go.
So, I mean, if they kept I have no objection to the way the numbers are shown on the drawing. We want large identifying,
They
numbers.
need to be minimum of 6 inches, so they could either have the 515 as they're showing it on the leading edge pole, or they
Right.
could drop a little panel down between the 2 poles that has a 515.
I mean, I suppose it would be better process-wise to simply require that pole become the sidewalk side and have them, just with the condition that they add another pole and that the numbers remain the same, the way that,
Okay.
the way it's depicted. And if they didn't like that and they wanted to do a new plan, then they would just have to come back with another application. I don't want to make this more complicated than, it needs to be. but I also don't like the idea of, us not doing what we're supposed to do, which is to review these applications and, make sure that they're compliant. Does that sound right?
Yes.
All right, so, Commissioner Noonan, will you amend your motion to approve with the condition that the leg that's shown be moved to the sidewalk side and an additional leg be added to the other side with the numbers as shown?
Yes.
Yeah, okay. And I think it was Commissioner Corcoran? Was it you, second?
Yeah.
Yeah.
I just want to make it clear to them that they can submit a different sign.
Right.
altogether.
Right,
So it's
that's
clear
my
that
point.
if that's not a satisfactory result to them and they want to do an alternative plan, they're free to make a revised submittal.
Precisely, right. So, we're not, so the sign that we're approving moves the leg with the numbers as we see it here over to the sidewalk side, and another leg is on the other side that's blank. That's just black.
Yep.
And so subject to their submitting a revised diagram as I just stated, we approve it. If they want to do something different, like move the numbers to the top, add another panel, make it bigger, smaller, whatever.
They just
then-
submit a revised plan.
Right. Okay?
For your consideration.
Right. All right. Any other comments? All right. All in favor, say aye. Aye. Any opposed? Abstentions? All right. The application is approved with conditions. So now we have public hearing. The first item on the agenda, 2117 and 2118 Fairfield Beach Road, has been withdrawn for the evening. And so our public hearing is on 479 Westway Road, request of Westway Road LLC to provide a payment to the Affordable Housing Trust Fund in lieu of providing 2 affordable housing units within the development in the Design Residence District.
Chair, members of the commission, my name is Raymond Rizzio. I'm happy to be before you tonight. Representing Westway Road LLC with regard to this project at 479 Westway Road. We have been, over the last almost a year and a half, working toward trying to come up with some kind of solution to a situation that is very unique, and a situation that kind of separates us from a lot of the projects that we've developed. We've been working very closely with the Affordable Housing Committee, and now that leads us to you folks. I'd ask that this is such a unique situation, if you could just give me a couple minutes to catch up to how we got here, because I think it would be very helpful. And I don't know if you all have them, but basically that's kind of there's some exhibits in there that you might find useful in having some discussions, which were in our application. So this project really was originally approved back in 2006. It was the same developer that was doing Southport Green. Both projects were struck by the financial disaster, and both projects just took forever to go. This project took a lot longer than Southport Green to work its way out of its morass. Financials, basically with the parties involved at the time, ended up trying to continue to extend these approvals. Originally it was approved on 11 acres. I think almost 7 acres was in a design residence zone. It was approved for 16 very large, large condominiums. They were going to be flats. They were going to be built on top of each other, and they were 4,500 to 5,000 square feet. It was a big project. Kind of economics of it never made sense, and then the financial aspects of the financial disaster just threw the thing into a tizzy. So from there, the different people involved, whether it was financiers, the owner, to try and preserve these approvals, continued to extend the approvals. Then the commission adopted section 10-17, which required in design residence districts that from now on we're going to have some inclusionary zoning, and we want 10% affordable. So, but for the fact that this financial crisis happened and there was a disaster, this project should have been built 13 years ago. So, back in, I think, 2015, asked for a final 5-year extension, which they were allowed to do pursuant to a public act that was adopted. That denial was appealed, and a settlement was reached between the owner and the town, whereby they would be able to move forward. However, one of the conditions of approval would be that there would be 2 affordable units, consistent with section 10-17, which was passed subsequent to the original approval. So it was owned by a hedge fund. Our client bought it from the hedge fund. We came to you in May of 2017, I believe, and asked you for the ability to make this a project that worked. We shrunk the size of the project, we shrunk the units, and we, with your blessing, you modified the judgment, and we moved forward. So we start construction in about August. People are very excited. It's a community that people want. They want to stay in town. They want to be able to downsize but limit their the amount of work that they have to do. And it was a successful project geared mostly toward a 55 and over crowd. There's no kids in the project. It's taken a property that was paying $16,000 in taxes and had all sorts of environmental issues to something that now pays, I think, about $240,000 to $250,000 in taxes. But this issue started coming up. People were buying, we're developing it, we're putting all our money into the public improvements and everything else, and everybody started saying, well, what happens as they were buying, there's these 2 affordable units. Now, the prices were running between $950,000 and $1.1 million on these units, depending on what kind of upgrades you wanted, and these 2 affordable units would be at $205,000.
I'm sorry, can you just go over those numbers
$205,000
again?
at the time.
205 as
Right.
compared to $1 million.
$1 million, roughly, let's say $1 million. So now you have these issues where you have these, now remember, for a condominium community, it's a small community. 16 units carries the ball. So if you get a weak link out of 1 out of 300, you can absorb it. But when you have a weak link of 2 out of 16, and I don't mean to say weak link, and I'll explain that in an instance, where in these smaller projects, they have capital improvement, they can request capital improvements, they can have special assessments, and they're voted on. The Condominium Act just says the Affordable Housing Act says basically that when you decide if someone can afford this, you look at the common charges and you include the common charges. Then it's the 90, you have to be able to afford, the family affords, I think it's $98,000. And then you can afford a 10% down payment, 90% of the purchase price. And you can buy these units. One thing that's important, Mark and I discussed this, is that this, believe it or not, is the first for sale new construction condominium project under the affordable component in the design residence districts. So no one really tackled situations of this when there's disparity. And you have situations, for example, this project is very unique because it sits between the highway and a train station, train tracks. Acela flies by at 70 miles an hour. The owners are already talking about possibly building a sound barrier. They're talking about increasing security because of the location being island-like. They want to know that they have the ability to increase security on that. And with that comes special assessments. And if you have a $100,000 or a $200,000 improvement, and your condominium charges are $425, what you do in these types of developments, you hit everybody with a special assessment and says it's going to be, $20,000 a unit, cough up your end. Well, the problem with that is when you're the person living in the affordable unit, you're at risk because you're limited to be able to get in there with regard to income, with regard to savings, with regard to assets, but then you need to be able to have the ability to also then carry the unit in the other instance where there's, for example, large unforeseen operating expenses. You have a huge snowstorm and the snow keeps coming and coming and coming like we've had in the past. Well, in these small units where there's not a lot of ability to basically just pile them high and high, they bring in a tractor and they load up the snow and they take it away, and that all comes out of a cost. And it comes out of a cost much more than $425. So we have this problem that we're tackling. So we've heard that in other communities, Darien, Norwalk, Stamford, they've proposed payments in lieu of this affordable. And one of the things I want to make clear here is And I think this what makes this and I've been doing this 35 years, this is unique. I know we listened in on the questions about forming the regulation about payment in lieu. And this is one of the most unique situations I've had, where you have a regulation that was passed after an approval was granted. You have the whole mechanism moving forward through a stipulated judgment. You have the first ever new constructed for sale community subject to this restriction, with then a disparity that was never thought to be intended or thought out. So all those questions started coming. We started working with the Affordable Housing Commission. We met with Mark basically back, got to be almost a year and a half ago. We couldn't really go anywhere with establishing a fee in lieu because they had to establish the fund. Fund gets established. Now, at least if you pay a payment in lieu, we have somewhere for the money to go. So the discussion was, how do we do this? We believe, and I think Stanton Lesser believes, I think we've talked with staff, talked with Mark, that we're separate from what would be a regulation, because we're here to amend a stipulated judgment which required these 2 affordable units. So we talked and discussed this matter with the Affordable Housing Commission. And I got to tell you, it was great insight. Commissioner Corcoran, Commissioner McAleese, Commissioner Noonan, Commissioner Lipp, all the commissioners that were at the last hearing, listening to you go through Mark's presentation and listening to your comments and concerns, helped me a lot in formulating and addressing those concerns tonight. So we met with the commission, and one of the big concerns was nobody was looking for anybody to get a windfall out of this type of situation. So some of the towns have like a $10,000 payment. Some of them are up to a $200,000 payment. The commission felt very strongly that this should not be a windfall. Now keep in mind, we also did not get any bump. We didn't get any benefit. In other words, we didn't get a bump in density because of the affordable component. It was thrust upon us, and now we're dealing with it. So the commission came up with a 320% of median income, which in our instance works out to a payment of $300,000 per unit. I'm not going to say that on record, but I would think the theory behind that was not to make this a disincentive. We are not looking to eliminate affordable housing, but affordable housing comes in many ways. It comes in new construction. A fund like this can leverage money, give money, people grants in exchange for making their deed restricting their property. I know there's issues on Reef Road where people now have, off that project off of Reef Road, or one of the projects where there was a problem with the flood insurance, and people are having trouble affording the increase in flood insurance. So there's ways that this fund can be used that would be serviced well beyond 2 families that could possibly be at risk in a development on Westway Road. So one of those concerns struck out that the commission had was, look, we're not looking for this for people to come in, say, look, how do we buy our way out of this issue? And one of the things I think, I believe it was Commissioner Corcoran, he asked about, well, who does this really help? I mean, if we agree to this payment in lieu, who gets the benefit of this? And I went through it, and I really thought about it, we've discussed it. First of all, the Town Affordable Housing Trust will get $600,000. Currently, they have $500,000 in the trust fund. They get their trust fund, if you remember, is funded from 0.5% of new building permits. It will take $120 million worth of new construction to match the $600,000 that we could get tonight. Now, this will only benefit 2 families. As I said, that could be used to leverage, in many ways, much more than 2 families. And give a much bigger need, and like I said, double the size of the fund. Will it, one of the questions you also had is, well, if we get rid of 2, we have them, how is that going to put us any closer to our requirement? Right now, we have 433, they're required to have 433 housing unit equivalency points. Maybe, I don't think I have enough time to explain how they get to the 433 equivalency points, but it's a basis of number of bedrooms, size of the units, and you come up with a number of 433. We're currently at 334. And speaking with Mr. Wendt today, basically that if everything that has been, basically in the hopper, been approved, gets built, we're going to get to those 433 points. these two units have really not much bearing on whether the fact the town will be able to adopt a moratorium. But you will have the ability to create much more affordable housing than two units with the payment of this funds. So the second thing I'm thinking about, who else benefits? The association. I have a petition here. We have 14 current residents, and every one of them has signed a letter of support in favor of the commission granting this proposal. You know what, I'll give you these.
These are residents of the development?
All 14 of the development currently support this application. We've met with we met with the officers, we've met with everyone, and gone through this. I think I have enough there. And how does this help them? First of all, it prevents the possibility that you could have 14 people paying for 16 ways. It could prevent the possibility, if there's some kind of capital assessments or capital benefits that people cannot afford, that we end up in a situation conditional failure.
Yeah, we have enough, thank you. Yeah.
So you don't have this neighbor-on-neighbor situation where if someone can't afford to make the payments, they end up in a situation because, you know, pursuant to Connecticut law, condominium associations have the right to lien properties and then commence foreclosure proceedings. So it gives the association a benefit that everybody's sitting on equal footing, and it gives a small association the ability to absorb unforeseen costs or capital improvements that are required. And I said, who else does it do? What about the buyer? The buyer who gets to qualify for this, who gets to pay this $205,000, that it's got to take basically whatever savings you have to put a deposit down to enter into a community where it's most likely that the common charges and costs associated will greatly exceed $425 over a period of time. So that person who risks their savings, many times what they have to get into this is at risk of possible foreclosure, or not the ability not to be able to afford the capital improvements required because they're limited into what they can make. So that basically, you basically would take, if some of the improvements that would be proposed, or if some drastic situation could take basically most of somebody's expendable income. So we believe it puts the buyer at risk. The other is the town of Fairfield. Town of Fairfield has the ability to increase their tax base. Currently, the affordable units will be paying about $4,000 per unit. Should the affordable restriction be lifted, most of the units there are paying between $17,000 and $18,000. So it gives you somewhere between $26,000 to $30,000 a year in extra revenue with no kids, no roads, no pavements, money directly down to the bottom line forever. So the town, actually, from a monetary standpoint, gets to benefit from this. Last but not least, the developer. We asked that question because we were trying not, I believe the Affordable Housing Commission did a great job of making the developer last but not least, because the $300,000 ticket, in effect, that you're getting, or the fee that you're going to pay to get out of the restriction, in effect, basically allows him to recoup some of his costs, not make any profit on the units. In fact, what they basically do is just give him the ability to lessen the hurt.
Well, that math I don't understand. I have a couple other questions, but if he's selling the units for $1 million and an affordable unit would be $205,
Okay?
he's taking a haircut of $800,000, roughly.
I'm saying cost. The units, he has built the units at a loss. In other words, for example, in this, I can almost give you in this instance where the units cost, the land cost in acquiring the property was I have the numbers, but I'll give it to you broadly, and if you want, I can give you a sheet, were $125,000. The site work, utility costs, and everything else was about another $70,000 to $80,000. The unit's 3,550 square feet, high end were built at about $185 a square foot cost.
Just, and
No,
not
I'm
even-
explaining, I want you to understand why I'm putting it the way I'm putting it. Then when you take into account sales commissions, carrying costs, everything else, your total cost ends up probably in the high $800,000 to $900,000 range, plus a $300,000 exit fee. You're between $1,150,000 and $2 million for a unit you can maybe sell for $1 million, depending on the way the market's going now. I don't know where that's going to be. But the goal was basically not to let somebody turn this into a profitable unit. Now, do you understand what I'm saying? So what he's allowed to do is recoup his costs and lessen the loss that he has on those particular units. That's what he does. But he doesn't make money on the sale of those two units. The cost of those units exceed any kind of sales proceeds that he could possibly obtain. That's where I'm getting at. So yes, he does get to recoup his costs, but there's no profit at all in those two units. Yet there's the ability to create a fund or put into a fund such amounts of
Yeah, I get
money.
the other side. I get the, I mean, you've done a good job of laying out all of the different reasons
Correct.
why on the other side. But just from basic math, if it cost him, rough numbers, $800,000 to build, and he would have sold it for $1 million, okay? But has to sell it for $205, the developer is taking much less of a loss on these units, these two units, than it would have,
Correct.
right? If we didn't have to, if we didn't,
Correct.
if we didn't do this. Okay.
Yeah, and I think that was when we had these discussions, you know, if you need Mark to expound on it,
Yeah.
this was
Is Mark here available to talk with us and to answer questions?
There he is.
Okay, all right.
And they drive a hard bargain. They want,
Okay,
one of
no,
the
good.
things, like I said, that was very important with the Affordable Housing Commission, I think you'll talk with some other activists in the affordable housing community who were involved with this, was not to make this an incentive-driven prospect. And then keep in mind,
Yeah,
and I know Commissioner Noonan, you were very concerned about two things. You were concerned about precedent, and you were concerned about discretion. You always have total discretion. And as far as precedent, I don't think this sets precedent for anything. I don't think there's a stipulated judgment hanging out there with this factual-based scenario. There's not another newly constructed, for-sale project even in town currently.
I think the meeting that you're referring to, where you heard feedback on this, was at a planning session.
Right.
Where this was first introduced to us and where we had some reaction, is that right?
Yes.
Yeah, yep.
Yeah,
That's
and what I was,
thought.
what I was
That's all in
trying,
all.
but the concerns.
Here's my confusion, and maybe this may be a silly question, but I thought that planning that we had, there was a regulation proposal, a regulation amendment being proposed that
Yeah.
we have not taken up yet.
That's correct. And it was not, I think, discussed in the specific context of this proposal, like how it would impact this particular project. Certainly not this level of detail in terms of the numbers and all that kind of stuff.
But have we voted on that yet, though?
No.
That's what I
No,
thought, okay.
No. In fact, that's what's being put in front of us at the moment is a draft regulation amendment,
Okay.
which would
No,
allow.
we're not putting any amendment before you. We are seeking to modify our stipulated judgment. We are not here pitching an amendment. We are here for what I consider a very unique situation.
Oh, I see.
A situation
Okay.
that relates solely to this project, to a situation that is
Right.
unusual
And that's
given,
that was my question. Was
given the
whether we could deal with it.
disparity of
Okay.
values within the community.
You're not
And-
relying upon their
No.
proposed amendment, you're
No.
seeking to
We're-
use
we're-
that, so to speak, in the stipulated judgment.
In my
to modify it.
presentation, what I'm trying to explain why I believe our fee in lieu would be warranted.
And because we're talking as far as a stipulated judgment, we don't need
The amendment.
Okay,
Yeah,
thank you. Now I-
necessarily. I mean, I think that bears some
Well, their
some
position.
discussion. Yeah,
Their
right,
position.
okay.
I was getting confused. I thought we had passed it without
We,
me
we,
knowing
we,
it.
we had discussions with staff and with Stanton Lesser about this, and really, when it comes down to it, it was kind of the
I
same,
understand, Maggie.
kind of the same way, Chairman, that you modified the plan. In other words, you modified a condition of the plan that had a stipulated judgment for 4,500 square foot units. We came before you with a plan with not an application, but a modification to the stipulated judgment.
Yeah, okay.
When we're coming before you with regard to a fee, remember, this was not in the approval, it was in the stipulated judgment that gave rise to these two affordable units.
Right, okay.
Okay.
Commissioner Francis has a question.
Can you explain, are these two affordable units, how are they different than the other 14?
You can't distinguish between any of them.
They have the elevators?
The elevators were extras. They had, not all the units have elevators. If people wanted to pay for an extra for an elevator, they could have that. I would say, what percentage would you say have elevators?
Well,
Maybe half of the people
and
spend.
the finishes are all
Finishes in the
optional,
interior, you can't
up-
distinguish. From the exterior, you
Right.
can't distinguish at all. Size is identical. There's no difference in all of what you're driving by.
Because the assessments are very different.
Correct, because of the price limitation.
They're assessed in the 200s, and the others are assessed in the 600s.
Right.
They're selling in the three, you've sold one affordable?
There's been one affordable that the developer has retained.
Okay.
Both are under the control of the developer. But the reason the assessments are so low is because
Finished.
there is a cap on what they can sell for.
Yeah.
So the only time.
Talking
the
about tax
assessment-
assessment?
What's that for the?
The
for
tax
yes.
assessment?
Yeah.
So the only time that that will rise is it'll rise as the affordable.
Yeah.
The calculation rises. So the units are probably appraised, I think, at about between $205,000 and $220,000. The other units are appraised at the $1.1 million with an assessment of 700 and something because they're not subject to that restriction.
Of course.
So that's why the taxes on these units will only be $4,000.
But that will be the case with respect to any deed restricted affordable housing unit that is for sale. And to follow that logic, I think, is at odds with our position on affordable housing. But, that's for another discussion. So Commissioner Levy's been waiting.
Yes, I have a few questions.
Are you
I don't-
done with the,
Is it now an
obviously,
appropriate
we're all
time,
chomping
or-
at the bit here. Are you finished with your presentation? I don't want to interrupt, because
Yeah, I can
I'm
wait.
trying to hold back until you're finished.
Yeah,
Go ahead, because I think I'm I would like to, I could sum up, but I got a feeling I'd rather sum up after I'm done answering the questions or dealing with the comments of the
Okay,
commission.
so we have that, and then I would like to hear from Mr. Barnhart.
Sure.
At some point, with some questions about the Affordable Housing Commission's consideration of these issues.
So maybe the best thing for me to do is
Let's
to
field some
answer
questions.
questions of the
Yeah.
commission, then you can get your comments from the public, and then I'd like to come back and
You get a
sum
rebuttal.
up my position.
Yeah, you certainly get a rebuttal. Yep. So Commissioner Levy.
Yeah, I have a few questions. First, I know you say that the Affordable Housing Commission, that they were voted in favor of accepting $300,000 per unit. As I understand the minutes, they found that $300,000 might be an appropriate number, but as I understand that they have not taken a position one way or the other as to whether we should favor a payment in lieu. Is
I
that
think they
correct?
said that was reasonable, and how they came up with the determination was basically through the negotiation, a little bit back and forth with us to what number would be reasonable in this instance.
Yeah, but whether or not a payment in lieu of has not been voted upon by the commission.
I think they have a letter in front of you that they say that the $300,000
No,
is
yeah.
a reasonable.
Right.
I don't think.
I don't mean to interrupt, but that is one of the subjects on which I would
Sure.
like to hear from Mr. Barnhart.
Right,
And
okay,
I-
that might be appropriate then.
May I ask staff, is the letter from the Affordable Housing Commission?
We have the minutes.
Yes.
We
Okay.
do, we have the minutes. Oh, yeah.
So there's a letter from the Affordable Housing Commission that states that they find that the $300,000 payment is reasonable. They voted on that. That number did not come out of the blue.
Right.
And I think I don't know for certain, but I think they feel it's the commission's decision whether to accept it or not. And like you typically normally do is you refer them for recommendations.
Right, exactly. Now, if I understand you correctly, you're asking us to approve this in connection with an isolated stipulation.
Correct.
Whereas if you came here with an application requesting this, I don't think unless the regulations are amended, we have authority to do this.
Correct.
So it's only, in this particular case, to do something that we could not otherwise do for any other applicant.
That's what makes this situation so unique,
Right.
because we don't have the essence of the 16 units, and the origin of the 16 units came prior in time than the inclusionary zoning was
Right.
adopted.
Okay.
And that, I think that's really what makes this so unique, was that but for a financial crisis, the same, in effect, project would be built, the same thing that was approved, but for the timing, we wouldn't be dealing with these issues.
Well,
and-
hindsight is a wonderful thing. I mean,
Correct.
I mean, there's no reason, assuming we had the power to do this, that a developer couldn't come in and his declaration of condominium or his bylaws would provide for subsidizing the common charges and assessments of the affordable units.
I think what would happen is, until you pass an amendment, which there was much discussion as to whether it was enough, whether you have discretion to, whether you want to set a number, whether you wanted to just look at it on a project-by-project basis until you had thought through that amendment as applies to the whole town, that you didn't feel you were in a position, that no one would be in a position to come before you with what we do. We are in a, like I said, this is one of the most unique facts situations, and I'm sorry if I bored you through about 10 minutes
No,
of getting
that's
to
all
where we get, but that's what puts us in the position, I believe, to ask you.
I mean,
But that's
if
the
you-
problem
but
is-
that's going to be the same fact pattern for every developer.
No,
Have
it won't
you-
be.
I mean.
I'll tell you why.
For sale units.
No, because the for sale units, the projects will not have been approved prior to the inclusionary zoning
No,
being set.
that's
What
that's
other-
irrelevant, because as a typical condition of an approval of an extension of a permit, after that 5 years or what have you, we typically will approve the extension subject to the project complying with our regulations as they have been amended, okay?
I'm not gonna-
And the fact that this project took longer to come to fruition are the facts of the case. And going forward, every for sale affordable housing development is going to have the same metrics
Well,
about it.
they don't have the ability to come before you until you pass an amendment. Because we're governed by a
They
stipulated
can
judgment.
propose their own amendment,
Correct,
the same way that you're proposing a
correct.
a modification of the stipulated
Correct.
judgment. Right, I mean, I just, to,
That's my main problem here, and finish.
Go ahead.
We don't, at this point, have the power, if a regular application came, to do a payment in lieu, as far as I understand, correct?
they would have, the application would be to amend the regulation to enable it,
That's fine, but we
and
don't,
also at that, should you amend the regulation, we would like to take advantage of that.
that's fair, but the regulations have to be amended, so in any application
Yes.
to do that payment in lieu would have to have that, which we don't have yet. My concern, and where I was confused in the beginning, is you're asking us to amend the stipulation to do something we're not authorized to do right now.
No.
I feel like
that's
we're
not
putting
true.
the cart before
I'm
the
asking
horse.
you to amend a stipulation, which you have the authority to amend as you had.
But you're
we didn't
asking-
get- We
go
did
ahead.
not come back before you for a special permit modification. For when we changed the units from 4,500 square feet to 3,500 square feet. We came back before you to amend the stipulated judgment, just like I'm doing now.
Yeah,
That's
So it's
fine,
the
but
same
the-
power and authority.
But no, it's not though. We don't have that power.
Mr.
We
Chairman?
don't have the power to do what you're asking us to do in the stipulated judgment.
I don't think your town council would agree with that, at least that's when we.
I mean, our powers are derived from the regulations.
No, your powers are also driven by the authority to modify judgments, to accept judgments, to settle cases. You
But I
have
don't
that
think you
authority
can-
under your
But I
regulations.
don't think we can go into court and get expanded authority through settling in a courtroom what we can't do in here.
Well, may I?
Go ahead,
I-
if I'm missing it, but I
Well-
just feel like we're going outside of our authority unless we have this
I
amendment.
think that in order for, Mr. Rizzio, your application to hang together, we as a commission, have to acknowledge or accept that the condition of the stipulation that you comply with the amended regulation, 10.17, in order to get the extension, was not a regulation that you otherwise would have had to comply with, right?
No,
So-
because you unilaterally put that on your extensions. I don't think that that's a requirement under the law. When
That's
you
my-
extend an
there we go.
approval,
That's my point.
there is no requirement under the law for anybody to comply with the regulations as they have been changed over the years.
So this is,
They-
and I think this is a fundamental point of your application, because it's your position, as I think it has to be, that this project does not otherwise need to comply with section 10.17. And the only reason why you are is because it exists in the stipulated judgment. Right, and I don't know that all of us sitting here are of like mind.
Well, one of the things we could do is continue the matter till you get an opinion from your town council. But we had to go this direction when we modified our original plan.
Mm-hmm.
And
No, I remember that.
I will tell you, I don't know that I don't know that I.
Well, you didn't actually, yep, sure, Mr. Wayne.
I don't understand your point on that. The stipulation says that he needs to comply with 10.17.
I know, and so and I think the point is whether, if that didn't exist in the stipulated judgment, whether 10.17 would apply to the project and the extended approval. Mr. Wen?
Jim Went, for the record. My answer to that would be, is to go back, the commission did not approve the extension that was requested. The commission denied
Yeah.
the extension. That was challenged in court, because one of the reasons, the main reason why the commission did not approve the extension was because there was a subsequent change
Yeah.
to the regulation that the project did not comply with. So rather than litigating the challenge of whether or not your denial of the extension was valid, a settlement was reached.
Yep.
So it's correct that there is no regulatory authority in our regulations to do a payment in lieu, but because the provision to provide the two affordable units was only agreed upon in the settlement, that's under the auspices that we're discussing. So I think.
Yeah, that was
I
the
don't- I
issue
don't-
in the case.
Right, I don't profess, I'm not going to say,
Okay.
I'm speaking for the town attorney, but we did discuss this with him, and he thought this, because it was a stipulated judgment, that the commission has the authority to amend it.
Yeah. Commissioner Lee?
I don't
Yeah, I have
buy that.
see what I
one,
mean?
more of
Yeah,
a
fine.
suggestion.
Just for Chairman, this is not something we've taken a flyer on. We've been kind
No,
of working
no,
at this
I-
for a year and a
No, and
half,
I'm
trying
Not
to come
suggesting
through the
that you
proper
are,
proposal.
absolutely not suggesting that you are, but I think from a legal, logical flow, Commissioner Noonan is, I think, raising a very good point that needs to be fully understood by
Well, let me
all of
ask-
us in order for us to, consider
give an
the different issues.
Unless there was going to, I just have maybe an analogous question to maybe drive home this point, if I may. What if, and I don't know the height restrictions, let's just say it's 2 stories, and give me a second here. Just assume the height restriction is 2 stories, and you're coming here, instead of asking for the relief that you're asking for a 3rd story. That would be against our regulations.
I think
Do you
if
think that we'd be allowed to do that in the
I think
stipulated
if I
judgment?
stipulated to building a 3-story building and I wanted to come in with a 2-story building, I'd probably have the authority, you'd have the authority to do that. I don't think because the reg came after the approval, because the settlement, and the only reason these units apply to this application is, out of a settlement. They never came out of a special permit approval.
I
They
get
came
that.
out of a stipulated judgment.
I get that, but
That's
you're...
the technical
but you're stuck-
aspect why we're here.
But you're stuck with that at this point. But you're now asking us, okay, even if you go with your point that, you put on us this thing that we didn't have to do, the 2 units. Now what you're asking us is go almost, again, to beyond what the regulations are currently. The power is to get this payment in lieu. I mean, you're arguing that we went beyond our authority in some respect in putting this 2 units on you, because you could have had you wanted the...
Well, that the denial of the extension was improper. That
denial
was
of
the
extension
basis
improper.
of the appeal.
We had put these 2 units on you, but now you're asking us to go even beyond our current regulations.
Well, what you're just proving my point. You're saying.
No, I'm saying there's
what
2
you're
wrongs, don't make a
saying,
right.
You wouldn't have the, you're putting on, you put on a restriction that only came about through a stipulated judgment. You have the authority for everything that concerns that stipulated judgment. We, rather than just come before you realizing that possible inequities that could occur, did not just come before you and say, we made a mistake on that, throw them out.
I got it.
There's got to be some we thought that there would need to be some compensatory reason to do that.
Understood, but
And
at
that's
the
why we
point-
met with the Affordable Housing Commission.
When the 2 units were agreed upon because of the affordable housing, when the 2 unit affordable housings were put into the stipulated judgment, we had a basis in our current regulations for that, correct?
Yes?
Okay.
That's
And
what
that-
the regulations would have
That's what the regulations were at the
required for a
time.
new applicant, for a project.
Do we have, and this is driving home my point, do we currently have the power to do what you're asking us to do?
I think you do with regard to this application. I don't
Okay.
think you do with regard to applications that come through your
Okay.
traditional process. And I think look, I would have made the application to amend.
But I think my point is you have to wait for the
but
application to go
we've
through.
we've talked this through, and that's why we came this route.
Yeah.
It's not something that I had no problem drafting an amendment, because I do think it's a good idea, and I think there are issues where this commission
Yeah.
can look where a fee in lieu makes sense. That's why you start, and be contributory and create more.
That was the nature of the proposal that was floated at the planning meeting that you were referencing before, because there are circumstances where I think, we all can agree it makes sense, Commissioner Levy, you've been waiting
Yeah, I was just
patiently.
wondering whether the developer has representation on the association board at this point, and if so, what percentage?
The developer has
The owner of the units.
technically. Does he have the?
Is
No, he
he-
doesn't have control. The control has been turned over to the association.
Okay, that's my
That's
question.
that was the question?
Yeah.
Yes.
And is the developer a member of the association as an owner still, or not?
The developer still owns one unit,
Hmm.
or at least one unit, controls both units, and has the ability to vote, yes. But
Both
those
affordable. What
votes
about the
are by
non-affordable?
every other unit, huh?
What about the non-affordable units? How many are owned by the developer,
None.
if any? None. They've been sold to private parties.
Correct,
Yeah.
correct. We're trying, believe me, as I said, this process started a year and a half ago. And that's why we're here.
Commissioner Levy, any
Yeah,
more?
just, as it stands now, there are likely, if there's no change, there will be 2 affordable units in Southport, correct?
Correct.
And 600,000 is unlikely to fund 2 affordable units in Southport.
No, that's not true. There are, I think we counted, I don't know within the town, but I know there may be other units in Southport that would certainly qualify if people wanted to would deed restrict their units.
Okay.
The real issue here, and the push here is, I don't think, and I think that's why the other towns have looked forward on this issue, is that every other 830G, every other affordable project that's come with you, every other 10% of the units have been rental projects. So there's not the discrepancy. If you're talking about a $3,000 a month rent versus a $1,200 to $1,400 a month rent, spread over a large number of units, it's absorbed, and it's absorbed by the owner. In this issue, the owner of the project. In this issue, it's going to be, the problem and the discrepancy is going to be burdened on typically a small situation, a small association, and an individual owner who may not be able, who was able to qualify to own it, but may not be qualified to maintain it. Am I
That makes sense.
getting
Well,
where that
I
is?
have
And
a
it-
question with respect to that, but I'm waiting till so other people can have a chance here. But
And just, but if the bylaws had been amended back then or now, where 7 would support 8 units, even at 20,000, it would cost them maybe an extra $1,000 each a year.
Well, then you'd be asking that you'd have every condominium association at the affordable units. You want them to be all treated the same, but you're saying you don't have to pay your way.
You pay your
And
proportionate
that's
share.
not the, yeah, and
And the
right now,
million-dollar owners
right
could
now,
pay a greater amount.
every cost is 1/16th. Is the suggestion that every cost be 1/14th and the non-affordable units bear the entire budget?
1/14 plus 20% that would be paid by the affordable. So they would pay 1/5 of the common charge.
I thought that was the case.
But that's not what the regulations require.
No, but it
And
would
that's
have been,
not what the law
it
requires.
would
I thought
have been a solution with hindsight.
I had thought so.
It would have been put a burden
I didn't
on,
know.
on people who are the owners in the community, who are the
Right.
residents of the town, yeah.
Hmm.
Be an unfair burden, I believe, versus where you have a development in a rental community where it's part of your overall. See, the problem becomes is when you shift from an overall box that one person controls to small boxes that 16 people have to contribute to, that maybe only 14 people can afford. And that is due to the disparity that was not anticipated, I don't think would have been anticipated by this commission even, that there would be this kind of disparity in the issues, and the issues that arise in this project because of its uniquely where it's situated. So, this is not an easy, you know.
okay. Commissioner Levy, any more
Nothing
questions
further.
on that?
Thank you.
No. Commissioner Corcoran.
I think mine are fairly quick. Who occupies the affordable housing units now?
One is unoccupied, and one of the members of one of the principal developers has qualified.
And I thought the requirement was that the affordable units be sold at the same rate as the other units. So if you have one unoccupied, is that because you can't identify anyone who would want it?
No, they've all been advertised. They've been advertised for rental. I've got the publications. We went through this all with the Affordable Housing Commission, and we were questioned. We have advertised these things. We have copies of I have them here, copies of the advertisements that were run in the paper, and
Okay,
we
I
didn't get the
understand.
responses that we thought.
All right, my second point is, you have the option of renting these apartments rather than selling them, don't you?
Correct, and not one person responded to the advertisement for the rentals.
Were they at the affordable rate?
Yes,
And through the Affordable Housing
because you
Commission,
have to,
does
it's
stop?
how you have to also have to be able to comply.
Employ-
Oh, yeah.
But it seems incredible. I mean, we have
Yeah,
a
it does.
huge need for affordable housing, and yet you're saying you can't find anybody?
Our client did everything with regard to the statute. He's shown every respect what he's advertised, what he's listed as. He's shown it to the Affordable Housing Commission. He's shown it to some of the affordable housing advocates.
Well, it sounds like you've created evidence that we don't need affordable housing.
I mean, I think that's pretty funny, but that would certainly not be what I would, what
Okay.
Yeah.
and,
Did-
and,
Yeah.
you know, I'm
Did-
I'm not being a wise guy.
No,
And
I
I'm
know,
not- and
no.
I'm- and I-
I'm
and I-
sorry.
And I'm not here trying, I believe what I'm saying. I believe the people that benefit from this will benefit from this, and I think it's a multitude of parties that will benefit from this.
Okay.
Did I hear you say that the developer, a principal of the developer
He's one of the people, yeah, he could qualify.
qualified
Yeah,
for
because it
one of the
depends on
affordable
your
units?
net assets, what your net income is, have you owned a principal residence, and you'd go through
Mm-hmm.
an entire checklist, and there are people that are able
So-
to qualify.
I mean, it's an interesting fact, but, so you're asking us, though, to look at amending the judgment to provide for a payment in lieu when the developer's already sold one of the affordable units to himself, or well, the entity has sold it to one of its principals as an affordable unit. What would you do? Reverse that transaction?
You don't, once the restriction, first of all, I want to make it clear, it's a relative of one of the principals. Principal, it's not the principal himself.
Okay, it's a little bit
Just why-
different.
I don't want somebody to say, wait a second, it's a relative of one of the principals.
That's a little bit
Secondly, once the restriction is lifted, it does not matter whether it was sold or not sold. So what happens is the restriction is lifted in exchange for the payment.
And so suddenly, the relative of one of the principals of the developer was able to buy $1 million home for $205,000. The developer contributes $300,000 to the Affordable Housing Trust, and suddenly that relative of the principal of the developer now has an asset that's worth $1 million.
The developer could put it as part of, a person could put it, if they qualified, could put it as part of their estate plan and hold it for the time period also.
But has it
We're
already
not
been sold?
trying, look, the issue is not to
I don't
personalize
know.
this.
That's a little weird to me. I don't know. That's,
So has it been sold for 200,000?
I had a couple other things, but
Property has been, one unit has been sold for $205,000
So you could then,
to a compliant party.
right, so you could pay 300,000 and then that party could sell it for $1 million.
The options probably.
What's that?
The options probably aren't there.
We would have the ability to not sell the units also,
Right.
or
well, I
rent the
know.
units and do
That
the same
actually
thing.
pays for it.
A
That actually
developer
pays
has
for it.
a person who
Because it's the
owned it would have the
relative who then
ability to
puts it on
rent
the
them.
market, sells it for $1 million, and then just finance the payment to the trust fund.
Chairman, the developer would also have the ability to hold it,
Yep.
rent it, and sell it if an amendment were passed or the commission ended up stipulating it. I think, I'm
Is
trying.
the relative that owns the unit right now having difficulty financially living in this complex?
The person qualifies to live in the complex. I think that's all that really needs to be said, right?
but
Yeah.
you're making an
Except
argument.
a big
that the-
part of your argument was that people can't buy these units and live there because of the assessments, the monthly charges.
I'm saying, yes, that's true.
So this person is doing
A lot
that.
of people would not be able to.
But the current owner is doing that. They're able to meet the assessments and monthly maintenance.
Because there also has not been any special assessments, there has not been any capital calls, there is capital expenditures going there.
I don't know.
But there's two planned, it sounds like.
Okay.
Sound
Alright.
barrier and the security.
What's that?
Well,
You said there was a sound barrier and thing about putting up.
The
and
security.
Over the years, there's new roofs, there's paving, there's all sorts of special assessments. I've had condominiums, which I've had family live in, where they've gotten a $20,000 special assessment for new windows. Now, that's becomes the very difficult.
for new windows in the clubhouse, right?
No. A lot of times, the windows are covered by association, the roofs are covered by associations.
You telling me that and I don't have those details in front of me right now, but the condos in this facility at
I don't have
on Westwood,
I don't have the regulations in front, the condominium, but I can tell you right now, condominiums I've owned, I've gotten a special amendment, a special assessment for windows because the seals are broken, the association pays for it. That is a common occurrence. I can
on
tell
your
you.
unit. I guess there's interior and exterior, and so I don't.
That is, anything that's part of the structure from the sheetrock out
For
is
even when
typically the responsibility of the condominium association.
even in freestanding. Okay. I don't have that in front of me, so I don't know, and you don't remember offhand what that is for this particular.
I can tell you the roofs are, the chimneys are. the siding is. All of that, these are townhomes, connected.
Yeah.
All of that is covered, all of that the association pays for. Painting it, covered by the association.
Wouldn't somebody who buys an affordable home have to pay for that upkeep themselves anyway at market rates? Like, if their house needed to be painted, wouldn't they have to get the house painted? If the chimney needed repointing, wouldn't they have to get the chimney repointed and maintain their residence?
They'd have control of their own unit, and they'd have 100% vote as to what capital improvements they want to or
Yeah.
do not want to do, or expenditures they want to incur.
Okay.
When you are in a condominium association, you have a
don't.
1/16 vote, and if you're outvoted 14-2 or 15-1, you become subject to that special assessment or capital expenditure, whether you like it or not.
And I agree with that. I mean, I understand that, and that's fair, right? I mean, there's an element of control, timing, financing, and all of that. But question I've been waiting to ask is, how does this work elsewhere? Because what you're describing is, I think, a situation that would apply to any affordable rate for sale unit in a complex that has common charges. And
Well, if you
and
can, if you
go
can-
ahead.
If you can see, we've given you the regulations, I believe, for Darien, for Norwalk, for Stamford.
Yeah, for payment in lieu.
Deeds in lieu. What's that?
For payment in lieu.
Payment in lieu.
Yeah, I'm talking about how it works as as a practical matter.
Here's
For
what's- 'cause you know-
affordable units
Because,
for sale
right,
in a circumstance where there are common charges.
I'll tell you what
Whether it's a
happens.
condo
Yeah.
or, what, okay?
here's what happens. Typically, most of the things that have an affordable driven component are 8-30G applications. Those 8-30G
Yeah, okay.
applications, condos, restricted units, whatever they are, they have the 8-30G units are closer, because it doesn't work, they're closer in disparity with regard to rentals. In other words, they're larger projects because they got the bump in density for being affordable, so the overall project can absorb the smaller disparity in rentals and values. Okay? A lot of the towns don't have inclusionary zoning, and they don't have it certainly in the for sale type component. There's a bunch of towns that I deal with that don't have any inclusionary zoning, and the only time it's usually administered is in a situation where it's typically in a rental community.
Right. Okay.
The
All right.
question was,
Yeah. So, thank you.
One of the
Other
things,
que-
if you can ask Mr. Barnhart
Yeah.
when he comes up, which I'm happy, if you can ask him about what this money could possibly create.
Yeah,
And
I do.
secondly-
That's
And
one of the
secondly,
things
some of
we're
the, what's important, because I don't know that I can ask him questions,
Mm-hmm.
but if you can ask him about some of the challenges that they're having with other homeowner-owned affordable units.
Yeah.
And the challenges those people are facing.
Well, the way that I'm viewing Mr. Barnhart coming up here is as a witness in your case in chief. So you can ask him any questions that
Thank
you
you.
want.
Then
Okay?
I'd be happy to do it.
Yeah, so,
Okay, so also, I'm
um,
going to step aside for a minute.
Yeah, unless somebody else has a specific question for Mr. Rizzio. Yeah.
I have a
Commissioner
question,
Gordon.
this might be just, I don't know, but if everything is 1/16, isn't the assessment also, wouldn't that also be less for those people?
It would be, what Mr. Rizzio is saying is that the assessment is not moderated according to the affordable formula. You buy the home under that formula, 205,000 instead of $1 million.
Right,
But then
right.
once you're in, you're a homeowner like everybody else.
And you're
And
not-
if there's a $10,000 assessment, all 16 units get a $10,000 assessment. You're not moderated because
I
under,
see.
an affordable circumstance. And that is I think, the thrust of the
Well,
argument.
you asked me, what I wanted to do is lay out the multitude of reasons why I think this
Yeah,
makes
that's
sense.
one of the key
Sure.
arguments that he makes is that the circumstance enables those of limited means to purchase the home, but then the circumstances of the condominium association don't allow them to afford to
For example,
continue
in a
to
house,
live
you
there.
know, in a condominium association, they're paying landscapers, and they get as many trees as they want. You own your own home, and it's an affordable unit. You can cut your own grass. You can plant your own shrubs. You can plow your own driveway. When you become an association, you don't have the ability to handle expenses in the way you see fit. You only have the ability to handle those expenses in the way the group sees fit.
Yeah, okay. I think we get it now, right? Yep,
I
okay.
have a couple.
One more, go, yeah, a couple, go ahead. Commissioner,
Quick,
Mr. Corr.
these aren't questions, just two quick comments. One is that the payment in lieu isn't the same as providing a unit of housing. And
Correct.
the goal is to provide a unit of housing, not to generate cash. The second thing is that I think one of the intentions of 830G is to create mixed neighborhoods. And the idea of taking what is a high-income neighborhood and saying that the affordable units shouldn't be there because of these common charge issues and so on, it flies in the face of that goal.
Yeah, I mean, I think that's a comment that we should save for executive session when we're, you know, I mean, that may be ultimately where your philosophy lies and, you know, where you come out on all
No,
of this. but-
you made that comment
I did.
when there were discussions with regard to the amendment, which had nothing to do with this particular application. We don't feel that this is the ability to move affordable housing out of Southport. We feel that we have a unique situation separate from things that would be addressed in an amendment that kind of needs an addressing, and we're looking to you for some kind of relief. And the association's looking for you for some kind of relief. And you know, who knows, down the road, it may have been the buyer who doesn't understand the circumstances which are thrust upon them that maybe would need relief. So this is not, I'm not in the protect any neighborhood from affordable housing business. I'm in here trying to say that there's a lot of reasons why in this particular case, in this unique fact scenario, that it makes sense to do a payment in lieu. That's, I'm not dying on any sword. I don't live in Southport.
Right.
Yeah.
I live down the street.
Okay. Well, let's give you a break and Mr. Barnhart, if we could. What's that? Let's when he comes back.
Okay.
Okay.
Who comes back? Me?
Mr. Rizzio.
Yeah,
Hello,
save those
Mr.
tough
Barnhart.
questions for Attorney Rizzio.
Yeah. So why don't we start with that question that I asked, which is, how does this normally work? Affordable housing, inclusionary zoning, where you've got a condo association or any project that has common charges. Is it typically the case that the common charges will be moderated to the affordable owners, or do they pay their equal share? You know, there's got to be some model for this somewhere. This can't be the first time this is coming up.
Well, first, Mark Barnhart, Director of
Thank
Community
you.
Economic Development, for the record. It's a relatively new field for Connecticut. I mean, there are other states that have taken more of a leadership role in this regard. Certainly, when you calculate what the for sale price would be of a deed restricted affordable home ownership unit, for example, you need to take into account some of those other factors. I don't think, you know, the question of special assessments is a different matter entirely. Affordable home ownership does present some unique challenges, different from rental units. I think when the committee presented and you adopted an inclusionary zoning provision, our focus was primarily on rental units as opposed to affordable home ownership units. But we did make a provision, and you accepted an amendment to our subdivision regulations that would cover both, both in the zoning regulations themselves as well as the subdivision regs. So it does anticipate that you could have both for sale and for rent units that would be covered by the inclusionary zoning provisions. I don't think we anticipated fully this particular circumstance. I don't know if that could ever be fully anticipated at the time we proposed that amendment. to you. There are a number of communities that do have a payment in lieu provision. The committee, at the time in which it presented to you an inclusionary zoning text amendment, regulation amendment, had considered whether or not to include a payment in lieu provision. We opted not to. Some of the reasons that Commissioner Corcoran mentioned. Also at the time, as Attorney Rizzio pointed out, we didn't have a housing trust fund, so it was partially a moot point. So there are payment in lieu provisions elsewhere. We did take a look at those in the context of this particular instance. The committee did have occasion, at the request of Attorney Rizzio and Mr. Tatangelo, to meet with both to understand their perspective and some of the issues that they've presented to you here with respect to Westway Road. Again, I think the committee asked a number of the same questions you did to understand better what those circumstances are. Came to appreciate that there are some challenges there. We can't completely dismiss the issue as it relates to special assessments and what that might mean in terms of a financial burden on a truly low-income homeowner that's in one of those units. And so in that regard, the committee was willing to look anew or take a fresh look at a payment in lieu provision, given the fact that we did have a housing trust fund adopted and we had provisions to include that. It was not a unanimous opinion within the committee. Ultimately, as Commissioner Levy was noting as relates to the minutes of the meeting, I was authorized to present to you a proposed amendment to the regulations, which provided a formula. And I think the thinking of the committee was, while we understood what brought it to our attention was Westway Road, I think the committee felt uncomfortable dealing with this as a one-off and felt that if we were going to allow the commission, this commission, to consider such matters, it should be at your discretion for this project and potentially others in the future. I can say that the overwhelming consensus within the committee itself was that those circumstances should be limited. That decision-making authority should rest solely with the town. The discretion should be exclusively with the town, this commission.
When you say the town, you mean this
This
commission?
commission. And, you know, again, looking at how other communities have dealt with the issue in terms of those that do provide for payment in lieu, we felt comfortable proposing $300,000, or what, in essence, we did talk about $300,000, but we ended up presenting to you a formula that essentially produced that same result. And that compares quite favorably to the 3 other Fairfield County towns we looked at that do have these payment in lieu provisions. It was, as I said, it's not a unanimous judgment on the part of the commission, but the commission felt, or the committee rather felt, that we should provide that. And we looked at it as an additional tool for this body. So if you felt in your judgment that it made sense, it was a good benefit to the town, you had that ability to consider a payment in lieu of providing units on site. So that is the background.
Okay. So I have a couple of questions, but I want to turn it over. So Commissioner Gordon,
I have a question that is, I don't know who would be.
can you
more,
just pull
but-
the microphone a little closer to you?
Yeah, so I have a question in that, so let's say someone buys it for, you know, the affordable housing, they buy it, and then they can't afford it after a couple of years, and they decide, well, they could just sell it, right? How does that work? How do do they have to sell it for the same rate, or?
There are resale restrictions in place. I guess, again, to your question earlier, and how does this work? We do have 45 deed-restricted affordable home ownership units in town. 22 of those are fee title with deed restrictions in place. There are restrictions both in terms of the resale price as well as the prospective purchaser. The prospective purchaser has to meet income eligibility requirements. We do have the other half of our units are in a condominium association, and we have had some issues. This is 100% deed restricted, but even there we've had issues where there has been common charges or assessments that have gone unpaid, delinquent, then the association sues the other individuals. So it does happen. And again, those things are made, those decisions are made in common as opposed to a person deciding whether or not I want to replace the roof on my house, which is a situation we have in the other development we were talking about.
And those 22 the half that are not in the 100% affordable condo, those are fee simple, single-family, freestanding homes?
That's the Navy housing, the Parkview Commons development. So those are all, they have fee title, subject to restrictive covenants,
Yeah.
both in terms of resale price and the prospective purchaser.
Right. Okay. Good. Good. Commissioner Levy.
I mean, it appears that one of the issues here is a lot of these concerns or problems weren't contemplated along the way in this particular project. I'm hard-pressed to think of a situation in the future, while I'm all for having the discretionary power for a payment in lieu. When would I want to use that? Why would I not just prefer that the developer take into account these concerns and maybe make that a provision going forward, or accommodate this in the future, so that in fact diverse neighborhoods and affordable housing can go forward? I mean, why would I need this power? Why should I need this power in the future?
It's a fair point, and Attorney Rizzio and Mr. Tatangelo were not suggesting that we present to you a proposed amendment to the regs to provide for a payment in lieu. I'm conscious of the point that Commissioner Noonan raised, but that wasn't what they were talking about necessarily when they presented it. Was as it relates to Westway Road. I think the committee, the Affordable Housing Committee, felt uncomfortable given the circumstances and the fact that it was a development already in place that was subject to a stipulated judgment between, we weren't a party to that, it was between the town through the Planning and Zoning Commission and the developer. Felt uncomfortable just dealing with that circumstance, felt more comfortable presenting to you a proposed amendment, and whether or not you chose to exercise that discretion or that authority in the future is solely up to you. And again, I think from the committee standpoint, I can say absolutely 100%, the committee would much prefer, as a general rule, to create the units on site as part of a mixed income community. We get the benefit of those units up front as they're built. But there are maybe circumstances in the future where you do think it would be advantageous to the town to accept a payment in lieu of creating the units on site. And so I think the consensus on the committee was, let's present a proposal to you that would allow you to do that, and then came up with what is a reasonable formula by which we can calculate the value of that unit. We looked to other communities, discounting, communities like New Milford and other places that really had a very low value, weren't really comparable here. But so we looked at Fairfield County communities that had inclusionary provision, had a payment in lieu option, and we came up with a formula that compares favorably to those in terms of producing a value.
Right.
There is obviously a difference of opinion there too in terms of what's the appropriate value, and I think I discussed that in our planning session. There are a lot of different ways to calculate that. We came up with something we thought was a reasonable formula and one that I could recommend to you, but there obviously is a difference of opinion there too.
So to be clear, it's the Affordable Housing Commission's view that we ought to consider an amendment to the regulations and then this particular project as a discretionary act under an amended regulation.
That was the committee's viewpoint, yes.
To Commissioner Noonan's, I guess,
Well, I thought he had
point.
just said that he, maybe I misunderstood what you said, that I thought he said that the committee didn't feel like they needed to pass the amendment first. They felt that they didn't want to get involved with giving an opinion about this specific
Correct,
issue.
That's true.
yes.
Okay, so,
But we
Then I'm-
don't, let's be candid, the reason we're having this conversation, the reason that we presented to you a proposed formula is the circumstances that gave rise to that are the situation with regard to Westway. I think in our planning discussion, it was not specific to Westway, it was if you, in your judgment, think it's appropriate there, you can consider it in the future as well, but
Right,
it was really
because
a proposed
That,
amendment.
and that was one of the, and you'll just give us a few more minutes, okay? 'Cause you-
He's jumping at the...
Yeah, yeah. 'Cause that was one of the more confusing things to me in reading through all the materials is that, you know, the minutes from your meeting specifically say, you know, he suggested a text amendment to cover future occasions for payment in lieu. The final decision on the text amendment is in the hands of the P&Z. A motion was made and seconded to accept the addition to the subdivision regulations. The motion was accepted and a vote 4-1, which to me means we should be considering a text amendment to the regulations and then considering whether this proposal for this particular property is one for which we should exercise our discretion under the amendment.
That was the viewpoint of the Affordable Housing Committee. I don't think that's necessarily the viewpoint that the applicant shares, but
Got
that
it.
was the viewpoint of the
Yep,
Affordable
no,
Housing.
and I understand. Now, can you talk to me about the no votes, the adversary comments? I mean,
Yeah.
it was a split decision.
Yep.
What are the principal arguments on the other side?
Well, I think Commissioner Corcoran summed it up, which is there's a feeling that we should create the units on site as much, you know, to the greatest extent possible. I think there's unanimity on the committee as relates to that. I just think there was a member, and the members here, Steve Grathwall is a member of the Affordable Housing Committee, cast the dissenting vote. I don't want to speak for you, Steve, but that was essentially concern about providing a payment in lieu,
Yeah.
whereas providing, you know, the units on site. So I think that was the difference.
Yeah, so that leads into, I think, the question that Attorney Rizzio specifically asked me to ask you, which was, what can the town do with the $600,000 that is significant with respect to affordable housing that would be different from having the 2 units in the project here?
Well, I would agree with Attorney Rizzio in the sense that with $600,000, you could create more than 2 units or create more than 2 housing unit equivalency points. It would most likely be leveraged.
Amazing how loud that thing is.
Taking the 600,000, I mean, the easiest path for me would be to incentivize existing developers, property owners to purchase, deed restrict, renovate existing housing stock, multifamily housing stock, restricted for a period of time that qualifies, and we would yield much more than those 2 points.
So in the form of
Not
like
much
grants
more,
and
but more
loans,
points.
grants and loans and things like that?
Correct.
Yep.
Now, you may not create those units in this neighborhood. You may not do it as quickly as, you know, obviously we have units that are already built, not fully occupied, but built. So there would be a lag, and it would not necessarily be created in that neighborhood, but I am pretty confident that you could create more than 2 units or more than 2 housing unit equivalency points with 600,000.
Right. Okay. Commissioner Noonan?
if this commission were to decide not to do the payment in lieu, and I'm using that just as a hypothetical assumption, if the commission decided that even just now, before considering this application, not to do the payment in lieu, are you able to say what the Affordable Housing Committee would say about whether the the relief that they're requesting is appropriate?
Absent a text amendment, would the committee be in favor of providing some kind of stipulated judgment as relates to Westway Road?
If you're able to say. I know it's,
You know, my sense from the discussion was there was some discomfort about dealing with this particular case in the absence of looking at it totality. And I think, you know, maybe I'm misreading it, but my sense from the discussion was, hey, if it's good for this, there may be circumstances around down the road where the same set of circumstances or similar circumstances may present themselves. Why not? Why just limit yourself to that particular case? Why not provide the discretion to this commission to consider that in other circumstances that may present themselves? So I think the committee felt, hey, this was not necessarily something that we fully anticipated. There may be other circumstances that we don't fully appreciate or understand now. You know, what's good in this instance may be good down the road. So that's how I heard the discussion.
thank you.
Okay. Anyone else?
Steve's nodding his head, so
Anyone else? Commissioner Francis?
I remember when the inclusionary housing program was created about 10 years ago at the state. Can you discuss what it allows?
Well, the inclusionary provision that it was limited to the area in the TOD overlay zone. And then as a result of your action, you extended the inclusionary zoning provision for all developments of 10 or more units, or that resulted in 10 or more housing units. So that was fairly recently. And we've seen a number of developments that have, you know, come before you and been approved and built that are subject to those provisions. So,
With for sale units?
they're all, I believe they're all rental, but
All rental?
yeah, except with the exception of this one
Okay.
so far.
And the word inclusionary basically means including what? Affordable housing?
Your current regulations provide that in a development that results in 10 or more residential units, 10% of those units be deed restricted as affordable to persons or households earning less than or equal to 80% of the area median income.
Okay. Attorney Rizzio? Anyone else have any other questions for? All right, Attorney Rizzio, you want to ask Mr. Barnhart anything?
Well, Mr. Barnhart just covered the issue with regard to the ability that this will benefit more than two families.
Right,
That
well,
this money has the ability to.
Yeah. There are different ways to use the money which would result in potentially more than two affordable housing
And-
units or
and-
credits.
I think also with regard to this area of town, I believe, I don't know if we were talking today, there was a judgment, I guess, that came down where the commission on Bronson Road has now a whole horde.
If you don't think that that's in the forefront of my mind as I sit here considering these issues, you'd be crazy.
Yeah, no, I understand that. So I mean, it's not a matter of not creating mixed neighborhoods. Neighborhoods are getting mixed. There's also.
Oh, I'm
within those
referring to the
neighborhoods are
fact that the
situations.
court told us that we didn't carry our burden in protecting the public health and safety and welfare of the citizens of the town in reversing, you know, our decision. But yes, the issues are of paramount importance.
Right. So what I guess we were trying to get at, is these communities are spread all over town. And there is differences in each of these communities. And I think the commission, the Affordable Housing Commission, at least whenever I met with them, and as you see, the motion that was accepted was 4-1. So it wasn't a split of, 10-4, 8 against. There was a lone dissenter. The fact that to move forward with the text amendment and have a text amendment that hopefully would give you folks the discretion to deal with these unique opportunities. We happen to be the hybrid, and maybe you need to refer it to council as to whether you actually do have the authority for me to be here tonight, but I wouldn't be here unless I...
Thought you did.
Without that process, correct. But the commission seems concerned that I'm here without having without having consulted with the town's council. And
No, listen,
that's
I have
why-
no doubt you did your due diligence.
Yeah.
I have no doubt you did your due diligence, and as you said, you've been doing this for a year and a half, and however it was. That was never my intention.
Yeah.
It's just a matter of, to be frank, whether I agree with you, but I think having Attorney Lester is something we're going to need to hear from.
Well, yeah. It does raise an interesting question in my mind as to, the timing. My understanding was that, the renewals came with compliance for, any amendments that came into force in the meantime and so forth. So we'll have to get an answer to that question, certainly.
I think the general feeling is, once you have a stipulated judgment, you write the rules. I think that's
Well,
basically, I think.
Unless
kind
there's
of
an intervener that comes in and says, hey, wait a minute, you are agreeing to do something which is contrary to, the requirements of the regulations. I mean, we're not permitted to do that, even in the context of, a stipulation.
I can enter into a stipulated judgment with you to, you get my neighbor's property. It doesn't mean you get my neighbor's property.
Well,
I mean, all rules don't go out the window, so to speak. And I know you're not suggesting that,
All I'm
but
saying is, there was a course that was set out as to how we were to proceed with you and why we could even make the application. So I'm not here on my own
yeah.
legal standing.
Commissioner Levy?
Just a question, does the court have authority to modify the judgment more than 4 months after it was entered without fraud or mutual mistake? What jurisdiction would the court have to reopen and modify this?
I couldn't tell you that. I couldn't
Party
tell you that, but I
consent, I
think you'd
guess.
always have the authority to go back with the consent of both parties.
Yeah. I mean, I think as a practical matter, not to get too deep in the procedural weeds here, but as a practical matter, if we came to an agreement to amend the stipulated judgment, we would simply do a joint motion in the court to enter an amended
Which is what we did
stipulation.
a year and a half ago.
Yeah, so I don't think that would pose too much of a problem.
I
Okay.
think there's other people I know that want to hear on behalf of our
So, yeah, are you?
Then I'm going to reserve comment until everybody's done.
Yep.
Or if the commission needs to continue this matter to get further input on.
No, I think we can consult with town council and staff after the close of the public hearing in between. So if you're done with your presentation, I'll throw it open to the public comment. Is there any members of the public that wish to be heard? Yep. Come on up. Now I feel like I'm talking really loud. Before I felt like I had to yell into the microphone for everybody to hear me.
That's just me.
Hi, I'm Steve Grothwell. I live at 132 Adley Road. I am a member of the Affordable Housing Committee, but tonight I'm not speaking in that capacity, but as a resident in town. On an aside, I want to say that I thought Mark did a really good job in the presentation, as he always does. And I think he filled in exactly what the committee was thinking when we met on this. But I just wanted to give the commission a third option to think about. Option number 1 is to do nothing. Option number 2 is the payment in lieu. Option number 3 would be for the developer to provide units off-site. If the town, if the commission were to get a payment in lieu, the funds are going to sit there for a while. In some cases, it sits there for a long while. But I checked. Today in town, there are 15 units for sale for under $300,000. A real estate person like the developer could acquire them, renovate them, make them available much quicker, easier, much more efficient than the town could do. So as you think about this, I just wanted to toss that third option into the mix. Thank you.
that was pretty good.
Thank you very much. Any other members of the public? Yes.
Jan Reaver, Beaumont Street. I'm going to speak really quickly so we get out of here by 9:30, which you'll be happy with me for that.
We're always happy with you, Mr. Reaver.
I support this application. I didn't at first, and I think anybody, Attorney Rizzio and so forth, will tell you that I was a very big skeptic of this. But I talked to Mike Santoro at the Department of Housing. He handles 830G for the state. He said he's never seen a situation like this. Obviously, you wouldn't have it in 830G because you can't do payment in lieu. But bubbling up to him are other affordable issues. He's not aware of any situation like this. He said, this is Fairfield County for you. We've got $1 million plus condo at an affordable rate. It just is a disparity in numbers that's unusual. And to me, that's really the basis of why I think you should consider doing this. It's a unique situation. I think if sufficient money is gotten from this developer, we're going to get more than 2 affordable units out of it, and that seems fair to the developer and fair to the town. What I'm concerned about is if you are considering approving it is the optics. You may be aware, for instance, with High Street, where there's a consideration of putting Fairfield Housing Authority property there. They've held public meetings, and a big issue is, hey, there's no affordable housing in Southport, there's no affordable housing in Greenfield Hill. That isn't fair. Now there's going to be some in Southport with Bronson Road, but the town fought that for years. So on the one hand, the town fought the only affordable housing in Southport, and now here they're going to take money not to have some others. So I think the optics of approving this are really important. The way you word a decision has tremendous impact for the public. I think you guys are very good at explaining your decisions in terms of public can understand it. I think this is a unique situation. I don't think anybody thought about the likelihood of 2 people being allowed to buy condos for $200,000 that are worth over $1 million. They're going to have the benefit of that. We're comparing that to what would happen if we could have 5 or 6 families having affordable housing elsewhere in town, but that's a much bigger benefit. We need to work to get affordable housing in Southport and in Greenfield Hill. I don't think this is the sharp edge to do that with. So this is what we pay you the big bucks for, to make these difficult decisions. So thank you.
Thank you. Anyone else? No? Mr. Rizzio?
It was going to be a short name. I apologize. You know, it's interesting. Mr. Graffo, I think, kind of hit a nail on the head, and I would hope, even more than this, that the commission continues to look at this, because my client would not have an opposition or any problem in providing the equivalent value of this money we talked about in Dean Lewin to actually provide the 2 units of housing. So we're not here to eliminate affordable housing. We're here to try and find a solution to something of an unintended consequence and a disparity that Mr. Weber talked about, Mr. Grothwell talked about, Mr. Barnhart talked about, and has gone on in discussion 1.5 years. Unfortunately, we've had to bring this to the forefront because it's one of those hypotheticals that somebody would have asked that everybody said that would never happen. Well, it happened, we're here, and how do we handle it? And we're amenable to continuing to work with the commission, whether it is to take the money that we would put in deed in lieu and instead come to you with 2 affordable housing, deed restricted housing units in the same general area. We're not looking to segregate the general, we're not looking to dive on any sword. We're looking to try and create a level, fair playing field without jeopardizing the town. As I said, I believe honestly in our proposal that it benefited 5 people, and I think all 5 parties benefited from the Affordable Housing Trust and possibly its commission, if we use this money, would use this money to go out and go get units that we could contribute in lieu. The association, in the fact that you don't have that potential and the possible issues where you have neighbor on neighbor, 14 paying for 16, and then the buyer themselves who may not want all the obligations that go along with maintaining these units or improving these units. They might not be of similar mind and of similar, they're not of similar circumstances because they wouldn't qualify for the affordable. Then you have the town itself from an economic standpoint, that this is not in any way used to be as an economic driver, but there's no economic detriment to them. And then, as I said, it's a little less hurt on a developer that really is probably the last and the least of the parties, but I had to address it because you certainly addressed it. We believe this payment in lieu, you're authorized to do it. I suggest you reach out to council and realize whether you're authorized to do it. I think that this is a discussion that probably will go on long past my presentation tonight and your decision tonight. But I think the other towns have looked at it. I think this town has got to consider it, that there are special circumstances. I think you should reserve for yourself the discretion to make good judgments, which you typically do, and create a level playing field, because that's the whole deal for affordable housing isn't to give somebody a bonus, whether it's.
But now you're talking about a text amendment.
What's that?
Now you're talking about amending the regulation, giving us the discretion to do it in the future. The application before us now is just specific to this, right?
Correct.
Yeah, okay.
Correct. But what I'm saying is, I was saying about the parties and the purpose of the affordable housing is not to give a buyer a bonus, it's to put everybody on a level playing field in certain circumstances. And in this instance, we think, given the disparity of what has been built, what has been approved, and the way that it all came about, that you have the authority to level that playing field. It's still either provide the money or the benefit of additional affordable housing. We could go on ad nauseum. I think you've all been done. I just wanted to make it clear, because I know a couple of commissioners, this is not our ability to thwart the idea of the affordable housing. $600,000 is a lot of money to anybody.
Of course it is.
As you heard from Mr. Rothwell, there's units out there that can go get now. If the Affordable Housing Commission can't do it, we would certainly entertain doing it. And
How do we deal with the fact that one of the units for which you're proposing this has already been sold, and sold to a relative of a principal of one of the developers, and that if we do what you're asking us to do, there will be a windfall to that owner of some $800,000 in value?
I don't think it's a windfall at all. He could stay there till he dies, and he can give it to his grandkids. There's no really, the windfall is no different. No, there's no different than
It's in value.
than to a developer who would rent it. I mean, I don't look at that as a windfall. I don't look at it as a windfall. I really don't. I think
It removes a restriction on the property, which results in a value increasing. Turn around and I'm struggling with it. I'm asking you how do I begin to conceptualize that?
I don't understand. I mean, I don't think that that there's any benefit there that's any different, to be honest with you. I think the units, you have the ability, there's a situation that has given rise to asking for relief from this commission that is not only relief, but opportunity. I think that's the difference. We're not just here saying line our pockets. We're here saying there's a better way to do this, and there's a multitude of at least 5 separate parties that we believe benefit from this request of a modification of our stipulated judgment.
Right. Does the person who owns that unit not want to be there anymore?
This person, no. I mean, he could stay there till he dies.
Question, if you're done.
Yeah. Commissioner Noonan.
Is there a time frame that you need a decision from us? As I said earlier, my initial opinion is you may be putting the cart in front of the horse. I almost would like to hear and have a decision, or have this commission take up the proposed amendment to get a sense of whether this commission wants to go down that route, to give us, in my opinion, to give us the authority to do what you're asking. But regardless of our differing opinions on that, do you have a time frame that you need an answer or want an answer from us by, a deadline, just so I'm cognizant of it? Besides obviously getting a decision sooner rather than...
30 seconds, because I think I have the answer, but, I don't...
No, go ahead.
All right, another question.
Yeah.
Right? Yeah.
My, because it seems like there's a lot out there. And there's a lot that's come up tonight and a lot of concerns, even more issues than when we had when you discussed the amendment. We could withdraw this without prejudice if the commission so desired. Give the commission the ability to consider an amendment. I mean, we don't have any timeframes. We could withdraw our request and either come back at a later date, take into account some other people's input, maybe work more with the Affordable Housing Commission to see if we can either help contribute to an amendment, contribute to a different level of stipulation, a different type of stipulation, and something that everybody would be comfortable with rather than trying to force a square peg in a round hole tonight.
Well,
I will say, and I don't want anybody here to make a recommendation, that's up to you. Nobody here is asking you to do that, okay?
Given the concerns of the commission tonight, given the questions that have been arisen tonight, and I hope you please don't think that I wasted your time and put you through an exercise, because I think these are issues that you're going to come up with, and I'm sorry that you had what was a short night, but I think in our best interests, and I think in trying to resolve some of the concerns, or seeing if there are ways to develop these concerns, I'd like to withdraw our request for a modification of stipulation, and see if we can come up with something that I think people will either be comfortable with, not comfortable with, or something willing to dive on the sword. So if the commission would allow me to withdraw this without prejudice, I make that request.
It's certainly, as the chair said, certainly your decision. I don't want to give any indication that had we considered the amendment first, that we would rule in any certain way.
No, but I think I want to be comfortable with our legal path. I want you comfortable with our legal path, and I think there are scenarios, options, and things that have arisen tonight that may lead to a better solution, whether by way of amendment or a better request for a modification.
Okay.
That's fair. For all those reasons, I'd request the ability to withdraw this without prejudice.
Yeah, that's fair, and you're certainly free to do that. Certainly, things have come up tonight that I hadn't considered before, and I, appreciate the candor. Don't feel like you wasted time. We vetted the issues and we talked about things thoroughly. We learned a lot tonight. All
I'll
right.
say your voice over the microphone is a lot louder when you're talking to me.
It's true, right?
I'm just kidding. Thank you, and I appreciate your time, folks. We will somehow, some way, some manner, hopefully be back before you again.
All right, very good. Thank you. So the application is withdrawn, and I'll close the public hearing, and I will adjourn the meeting. Oh, one thing before we adjourn. We have a very light, thank you for reminding me. We have a very light calendar for August 27th. We have nothing to schedule for a public hearing. So the proposal is that we have a cancellation of that meeting so that we can have our summer vacations.
Can we just move something to public hearing, or?
We did, but it's not ready to be scheduled.
Oh, okay, never mind,
So
sorry.
they're looking at a September date. So does anybody have any questions or problems or issues with that?
No,
Right?
of course not.
Okay, very good. Thank you very much. I'll adjourn the meeting.